Morning, Miss McLemore.
Good morning, Miss Wilson. How are you today?
Hi, I'm fine. This is Mary Ann.
Oh, I'm
Your
sorry. I'm
That's
sorry.
okay. Miss Wilson just signed on. Do you need a breakout room with her?
Um, no, I don't think so. I did speak with her briefly this morning. So no. Is Okay, Mr. Gann, is Mr. Gann going to be here this morning?
He's
Or
not
is
here.
it
He's not here yet.
okay? All right. Uh, so yeah, I can speak with her briefly. Okay. Thank you.
You're welcome.
Good morning, Your Honor.
Good morning, Ms. McLemore. How are you?
I am good. I'd like to apologize. I did send, file an answer and I sent, some pictures and a video. Unfortunately, Lakeshore Legal Aid's, computer system went down Friday. Well, it didn't go down. They had a mass, migration or complete update or whatever. So we weren't able to access our computers at all from Friday to Monday. And I did not have an opportunity to get things over to you sooner, to the court sooner.
So when did you send whatever it is that you sent?
Yesterday.
Yesterday.
Yes.
I reviewed today's files yesterday morning and I did not see anything, but I will look right now to see. The last thing showing as filed in this case was on November 3rd, so it might.
I sent it to the usual filing,
Through On Base.
just the 34, the district,
Oh, by the regular email address.
yes, yes.
Okay, give me one moment.
Okay, thank you.
Good morning. I need your help, please. Case number is 23 in regular email. Two three 01769 LT. It's Parkwood versus Wilson. Ms. McLemore emailed some documents yesterday to the regular civil email address. So they're not in On Base. I just want to check to see if you have them. And if you would just. Because he wouldn't realize that I had an LT docket on an off day. But Heather should have forwarded them either to Mary Ann or to me. Thank you. Thank you so much. Okay, bye-bye. They're here, Miss McLemore. They were sent to the wrong courtroom. They're sending them to me in a moment. And if Mr. Gann appears, then we at least have them.
Okay, thank you, Your Honor.
You're very welcome, ma'am. Mr. Hales, have you retained counsel on behalf of the church?
Hi, Your Honor. I didn't, but we did get the answers to our questions and stuff. Um, but we didn't hire an attorney. I did want to ask the court today if we're going to just go ahead and move everything out of the apartment. And I was going to ask the court if we could have at least till the end of the month to do that.
Give me one moment to call the case, sir. This is 2301265 LT. This is Edward Rose Corporation versus Messiah Lutheran Church. Can I have your
Yes.
appearances, please?
Good morning, Your Honor. Ryan Wojcik, PA 4535, on behalf of the plaintiff.
Hi, Ryan.
State your name for me, sir, for the record.
Billy Hales.
Thank you. Today is the day and time set for the adjourned hearing in this matter. The parties were here back on November the 1st. Mr. Hales appeared on behalf of the tenant defendant in this matter, and the court advised him that if he appeared without an attorney, the court would entertain the plaintiff's motion. Inasmuch as the listed tenant in this case is a corporation, Mr. Hales is not allowed to represent them. That being the case, Mr. Wojcik, how would you like to proceed this morning, sir?
Your Honor, at this time, we are requesting a default judgment of possession only. The updated amount since November 1st are rent to retain of $12,067.13, costs of $131.65, for a total of $12,198.78. Since this has been adjourned, we are requesting a writ date of November 27th, 2023. If Mr. Hales would like a 4-day extension or 4-day extension, I advise him to ask the landlord outside of court, and we will submit an order to that effect to the court.
Mr. Hales, did you understand that response?
I understood some of it, like about the writ date of the 27th, but my question is, I'm in court today. I would like for the judgment to be a consent judgment as opposed to a default
You
judgment.
cannot enter, Mr. Hales, you cannot enter a consent on behalf of a corporation unless you're an attorney representing that corporation. The court cannot allow you to represent them in this matter.
Okay. Well, Your Honor, can I go back?
So while I understand your request, I'm sorry?
So you're saying in order for us to be represented in court, we need to hire an attorney to represent us?
Correct, sir. And the consent judgment, the court would not, the court hears the plaintiff's attorney indicate that there would not be an additional time granted. The court would need to hear from the tenant a reason to extend the writ date. And I haven't heard a date. And just so you're clear, it doesn't mean that the plaintiff's office will automatically get a writ on the 27th of the month. They must make application for a writ. So between the expiration of that time on the 27th and the time they file the application for the writ and the time that it's signed, you may get the additional time you seek, or the attorney's indicated that you need to talk to the landlord about it, which is a conversation that happens offline, not on the record with the court.
I see. So in order to have the default judgment to become a consent judgment, I'm trying to talk slow because I'm not really understanding everything.
Why,
Um,
well, let me ask it a different way. Why are you looking for a consent judgment? What do you think that changes?
Well, I'm in court today because um, I'm just concerned about even if once we're able to like pay all of the debt off, we'll still have like a default judgment on our business. Am I correct? And that could affect us going forward in terms of other things that we do business wise. Is that
The judgment will
correct?
indicate that if you pay $12,198.78, you may stay. That amount must be paid by November the 27th.
By
So
November
when you're talking
27th?
about future effects from whether it's a consent or a default, it might not get to that point. So
So we just be taking a chance that whether or not it gets there.
If
I
I
don't
may,
understand your question, sir. I'm sorry, Mr. Wishart. Go ahead.
My issue is with
I-
the default judgment, and I did ask for the extra time, and you're telling me that a writ won't be issued until about the 27th, right? And that it might give us the extra time to move everything out.
That's not what I said. What I said
Okay.
is that
I'm
What I
sorry.
said is that the judgment that enters will say that the defendant Messiah Lutheran Church must pay $12,198.78 by November 27th or vacate the property. So if the 27th comes and that amount has not been paid, then the next day the plaintiff's office could file an application for an order of eviction. And then that document would have to be filtered through the courthouse to the judge for signature. So I can't say that that's going to take 5 days. It might happen the same day. I don't know. Because I
Okay,
don't know that the plaintiff's office will necessarily file the application on the very next day.
Yeah, it sounds like we should have hired that attorney, Your Honor. Am I right?
Anything else on behalf of the plaintiff?
no, Your Honor.
Anything else, Mr. Hills?
No, no.
Thank you, sir. Good luck to you. Have a good day.
Thank you.
And we will submit that order to the court. Thank you.
Thank you, sir. Ms. McLemore?
Yes, Your Honor. I have had some
This is-
communication. I'm sorry.
I'm sorry. This is 2301769 LT Parkwood Manor versus LaWanda Wilson. May I have your appearance, please, ma'am?
Yes, this is Danette McLemore. I am appearing on behalf of LaWanda Wilson.
And I cut you off. You were starting to say you have or have not had communication.
I have had communications with Mr. Gann yesterday. When I sent him the documents, he did call me and indicate that he couldn't open some of them, or he couldn't open my answer. So I did resend them again this morning to him. And he's communicating with me again this morning, indicating that basically he wanted to know if I had a cell phone so that he could call me. So I don't know exactly why he's not on the docket, but I was, that's why it took me a moment to get back, because I was trying to respond to his email, because we've corresponded back and forth a couple of times, but in the last communication, he asked for my cell phone, and I was sending him a response telling him that I'm currently on the docket, so I wouldn't be talking on the cell phone, but I'm not exactly sure why he's not present yet. But I have had communications with them this morning, Your Honor.
My policy is typically 15 minutes after the scheduled start time. In this case was scheduled at 9 o'clock. So how would you like to proceed?
Well, Your Honor, I would like I would like a dismissal. That would be the best for my client. I do have a concern in that, like I said, I have communicated with him this morning and he didn't indicate any reason why he wasn't going to be here. Again, he did, yeah, so I would request that a dismissal be entered.
This case having been scheduled at 9 o'clock is now 9:22 by the court's clock. The plaintiff having failed to appear, the court will grant the defense motion to dismiss this matter. The dismissal will be without prejudice. Ms. McLemore, should you have additional conversation with Attorney Gann and this matter needs to be reinstated, you may do that by stipulation. Otherwise, I would anticipate a refiling of this case or a motion to reinstate.
Thank you, Your Honor.
If you would send the dismissal over by on base, please.
I sure will. Thank you, Your Honor.
Thank you. Ms. Wilson, you have a good day. You're free to go.
Hey, no. Thank you, Your Honor.
You're welcome. Have a good day. Mr. Gann?
Your Honor, I apologize. I was actually in the other courtroom for a bunch of cases, same client. I didn't realize this case was in your courtroom and not the other one. So that's why I'm showing up 45 minutes late. I was having direct communication with the attorney on the other side from 8:30 this morning on, so I just assumed they were all gonna be called at the same time in the other courtroom.
The case was scheduled at 9 o'clock. I called it at 9:22 and granted her request for dismissal. If you want to, we can try to get her back on.
Sure, I'll put myself on mute. I'll try and reach out to her.
Thank you.
Thank you.
Yes, sir.
I was not able to reach her. I guess I'll have to file a motion to reinstate with this honorable court. I'm surprised. I had emails with her at 8:46, at 9:08, even when she was on the waiting in there, and at 9:14, we had emails going back and forth. She never gave me an indication that they were waiting for me. So
She did disclose on the record that she was in communication with you yesterday and today, but that she had no indication from you that you would not be appearing. And so there was some confusion about what courtroom you were, or what Zoom room you were supposed to be in this morning.
correct, Your Honor. I was actually just got wrapped up 6 cases with the first hearing cases with the mediation center, and I thought this case was with them. I didn't realize it was a second hearing, so I did not handle the first hearing on it.
Mr. Gann, what I will say to you is that if you are able to reach some sort of agreement with Ms. McLemore to reinstate the matter and get it rescheduled, I'd be happy to hear the matter on the 28th, November 28th in the afternoon, let's say 1 o'clock. But I
That was right.
can't,
Understood. If I'm not able to, I'll file a motion to reinstate.
thank you, sir.
Thank you so much for
I'll
your time.
keep an
Your
eye
Honor.
out for it.
Thank you.
Have a good day.
You too.
Mr. Morton?
Yes, Your Honor.
Good morning. This is 2301130 LT. This is Harbor Club versus Lakeisha Phillips. May I have your appearance, please?
Your Honor, for the record, Attorney Ian Morton of Pallets Law, P67892, on behalf of the plaintiff.
Thank you. Today is the day and time set for hearing on the matter. The case was scheduled at 9:30. It's now 9:46 by this court's clock. Have you had any contact or communication with Ms. Phillips since we were last here on November 1st?
No, Your Honor, I do not have any record of Ms. Phillips reaching out to my office since the date of this hearing. And according to the records that my client has, there has been no payments made on this account since August 8th, 2023.
How would you like to proceed this morning?
At this time, Your Honor, we would move forward to seek entry of a default judgment for possession only. Rents retained are $4,636.00. Court costs of $172.33 for a total of $4,808.33.
Thank you. Based on the defendant's failure to appear as directed by this court and placed on the record back on November 1st, default judgment shall enter in favor of plaintiff and against defendant with rent to retain possession of $4,636, $172.33 in court costs for a total judgment of $4,808.33. Plaintiff's office to submit the judgment for entry. Anything else in this matter, Mr. Morton?
Nothing else, Your Honor.
Is that a lion's pen?
Yes.
Thank you very much.
Here, I'm a
Have a good
Spartan and
day.
Lions fan. It's been painful for the Spartans, so I've got to find some pride somewhere.
I was bidding you adieu, but it looks like you're actually still here for the 10 o'clock.
Yes, we have a 10 o'clock. Was it for the Mr. Johnny Ellis matter? I know there's going to be another counsel that's going to appear in this matter as well when it pertains to the counterclaim that was filed from another attorney's office. So I know we have to wait for them to appear.
Okay, as soon as they get here, do you need to speak to, what is it, Mukherjee? Do you need to speak to the attorney for Mr. Ellis?
I think it would make sense once all the attorneys are here to be able to have an opportunity to be able to speak. Yes, Your Honor.
Absolutely. We'll keep an eye out for him. Thank you,
Thank you.
sir.
Mr. Morton,
Yes.
did you say that you needed a breakout room with opposing counsel?
Yes, I'm just waiting. There's another attorney that's going to be appearing who may or may not have filed an appearance already in regards to the counterclaim. His name is Attorney Cleveland Simmons.
Oh, okay, all right,
So we're just waiting for him, and then at that point, we can put into a breakout room.
got it. Okay, thank you.
Yep.
Mr. McCurdy, did you need to speak to your client?
No, Your Honor, we spoke yesterday. Everything's fine.
Thank you. Ms. Kohlrabi, did you need to speak to Ms. Messer?
No, Your Honor, I'm currently waiting for her attorney to log in.
Oh, Ms. McLemore, thank you.
Okay.
Ms. McLemore, did you need to speak to either Ms. Messer or the attorney for Huron Estates this morning?
If I could speak to the attorney for Huron Estates, that'd be great.
Thank you. We'll get you into a breakout room with them.
Thank you. Excuse me, Your Honor. May I be put into a breakout room with Ms. Master, please?
Absolutely.
Thank you.
You're welcome. Did you need to go back in with Ms. Karabi?
No, I believe we have a deal. I just needed to confirm it with my client. Oh, well, I don't think so.
This is 2301227 LT Huron Estates versus Alicia Messer. May I have your appearances, please?
Good morning, Your Honor. Laura Kruby on behalf of plaintiff.
Morning, Your Honor. Jeanette McNamara appearing on behalf of Alicia Messer.
Thank you. Today is a day and time set for the adjourned hearing in this matter. How are we proceeding this morning?
Your Honor, we have spoken and we've agreed to enter into a conditional dismissal in this matter. And Ms. Karabi, if you would like to put the terms on the record.
Of course. Your Honor, this is for possession only. Defendant shall pay to the following pursuant to the terms on or before November 30th, 2023, rent in the amount of $4,009 plus court costs of $168.28 for a total of $4,177.28. And this is going to be under 4B. And then I just need to send it over for Ms. McLemore to approve and sign, and then we can get that filed.
And also, there was a letter that I am going to be getting from Ms. Karabi. Did you send that already?
I already sent it to you.
Okay, great. I haven't checked my emails yet. Thank you.
Was there anything else in this matter on behalf of the plaintiff?
No, Your Honor, I don't believe so.
Anything else, Ms. McLemore?
No, Your Honor, thank you.
I'll await receipt of the executed conditional dismissal with a total of $4,177.28 due by November 30th with 4B. That concludes this matter. Ms. Messer, you're free to go. Ms. McLemore,
Yes.
on an unrelated, Mr. Gann did appear at 9:42. I advised him of the resolution of the case, encouraged him to reach out to you, and indicated if you reached an agreement with him, the court would be happy to take the matter up for hearing, the original complaint up for hearing on November the 28th at 1 p.m.
Thank you, Your
Otherwise,
Honor.
if you don't reach an agreement regarding the reinstatement, he'll file a motion for reinstatement and we'll schedule it in due course.
Okay, thank you, Your Honor.
Thank you. You have a good day, Ms. McLemore.
Thank you. You too, Your Honor.
Thank you. Have a good day, ma'am. Good morning, Ms. Caldwell.
Good morning.
The attorney is here for Trilogy Residences. Would you like to speak to that person before the case is called?
Yes, I would.
We'll get you into a breakout room.
Thank you.
This is 2301309 LT. This is Holiday Woods versus Johnny Ellis. May I have your appearances, please?
Your Honor, for the record, Attorney Ian Morton of Pallets Law on behalf of Holiday Woods in regards to the, termination claim.
Jay McCurgy, attorney for the defendant.
Cleveland Simmons, attorney for defendant Holiday Woods in the counterclaim.
Thank you. Today was the day and time set for hearing in this matter. Mr. McCurgy, how are we proceeding this morning?
Your Honor, we are going to ask for an adjournment so we can stipulate to removal of the counterclaim to circuit court. And we are going to ask to proceed with some discovery for the notice to quit or termination case, the summary proceedings case with Holiday Woods.
Is that an accurate statement of how we're proceeding, Mr. Morton?
Yes, Your Honor. I was just gonna see if we could just clarify a few things for the scheduling order. My office can put it together and send it over to Mr. McCurry as well. We're also gonna ask for an escrow order to be entered, which of course to be prorated starting today. It's as there is a jury trial demand in this case.
So this case, if I'm understanding correctly, will be bifurcated with just the counterclaim going to circuit court, determination remaining in this court, with the jury demand remaining in place?
That is my understanding. I would look to Mr. McCurry. It was unless they were going to withdraw that jury demand in the summary proceedings district court case.
The reason I'm asking that way is if the offset requested in the counterclaim is going to impact or affect this case moving forward, if the counterclaim, even though removed, would not stay these proceedings, is it not going to cover some of the same ground? Mr. Simmons, you're welcome to weigh in.
Yes, Your Honor. I don't believe so. The notice to quit or termination will have no effect on the counterclaim. It's a personal injury claim. It's claiming water contamination. He does have some allegations in his complaint about, lockout and things like that. I think those will be resolved in the circuit court case. And at the end of the day, the counterclaim is simply a personal injury claim. Any issues he has about his unit, water being shut off, those sorts of things are going to be handled with Mr. Merge and Mr. Morton, not in the circuit court case. And I'll be filing an answer on behalf of the defendant for the counterclaim. So I'll be filing a separate jury demand, and I don't know if we should wait until it's transferred or not, but there will be a separate jury demand for the counterclaim because I don't know if there is a jury demand for the counterclaim at this time.
I'll get back to Mr. Morton's request or clarifications in just a moment, but how long will it take you to file an answer and get the document prepared to stipulate to the transfer of the counterclaim to Third Circuit?
That should all happen before the end of next week, probably this week.
And keep in mind that there's a holiday next week too.
Oh yeah, there is a holiday next
That's
week.
why. Can you get that done in the next 14 days? I'll ask it differently.
Yes, within 14 days that can all be done.
Okay. And as for Mr. Morton, you indicated an escrow order, which of course is granted. That's number one. Number two, did you say discovery in this case? Yeah,
Your Honor. Was it the parties have asked for discovery? I can prepare a scheduling order. Or was it I proposed written discovery interrogatories, request for production of documents, and request to admit? Was it because we're limiting it specifically as it pertains to the complaint, the notice to quit complaint? Was it usually in district court, we'll normally limit it. Mr. McCurry, do you have any objections if we limit it to like 15 each?
I don't have an objection to that.
Okay.
I would also, Your Honor, like to state that it is my understanding that some of our counterclaim and affirmative defenses do have bearings on the summary proceedings, because if what we are saying and alleging is true, then there is an issue for them going after possession at this time.
Your Honor, I believe what they're trying to state is the fact that they're alleging that the termination is related to a retaliation claim. I know under MCR 4.201, it's H2, although it might have shifted recently with all the changes to that port, but it talks about summary proceedings need not be removed to the Was it to the circuit court? Was it, for a counterclaim or was it any sort of equitable defense?
Yeah, that's my understanding too. Mr. Morton's claim stays and the counterclaim goes to circuit.
The 4201 amendments are still relatively new, and regardless of how many times they're read, there's still some nuances. But what period of discovery are you looking for in this matter?
I mean, I would say 60 days, Your Honor. That's usually a pretty reasonable time. Gives us some time to be, especially with the holiday, just to kind of get everything together, exchange documents, and then if, as I like to say, if the parties are going to have a disagreement in regards to what the responses are, it still gives us time to be able to file something with the court.
I would like to get you back here more status than anything else, and before we schedule a jury trial in this termination matter. 60 days puts us, there's a holiday there, there's criminal docket there. I'm looking at the Tuesday, the 23rd of January of 24.
You said the 23rd or 24th, Your Honor?
The 23rd of 2024.
Okay.
January 23rd, 2024 at 9 a.m. back on Zoom. Let's call that a motion slash pretrial date. I don't know what else to call it. With us being on track for a jury trial, we're limited on when that could be scheduled. The jury trial would likely be about a month after that, January 23rd. If there's no motion that resolves this case or some other agreement between you that resolves this case, the jury trial will be that week of the 19th of February, but we'll get more into that on the 23rd of January. So we'll look for the stipulated order, removing the counterclaim portion, setting the time for Mr. Simmons to file his answer to that. Mr. Morton to prepare the scheduling order relevant to the summary proceeding portion that stays here with the 60 days of limited written discovery and resetting the matter for January 23rd. And if anything happens in the interim, please reach out to the civil department. Was there anything else, Mr. Morton?
No, Your Honor. I'll have that scheduler prepared and forwarded to Mr. McCure in the next 24 hours so we can get that entered with the court.
Thank you. Anything else, Mr. McCure?
No, Your Honor, thank you. Not at this time. I appreciate
Anything
it.
else, Mr. Simmons?
No, thank you, Your Honor.
Thank you. I'll see two of the three of you in January. Have a good afternoon.
Thank you, Your Honor.
Thank you, Your Honor.
You're welcome. Good morning, Mr. George.
Good morning, Your Honor.
How are you, sir?
Doing well, thanks. How about yourself?
Wonderful, thank you.
I'm here a bit early for my 11 o'clock, so I'll just hang out
I was just
until
gonna
opposing
say that.
counsel gets here.
Okay, thank you, sir.
Thank you.
Okay. This is 2301060 Trilogy Residences versus Jenny Caldwell. May I have your appearances, please?
Yes, Your Honor, I'm here.
Laura Kruger, Your Honor, on behalf of the plaintiff.
State your name, please, ma'am.
Jenny Caldwell?
Thank you. Today's the day and time set for the adjourned hearing in this matter. The parties have had the opportunity to speak. How are we proceeding this morning?
Your Honor, I have spoken to my client and we are in agreement with Ms. Caldwell for a consent judgment with rent to retain in the amount of $4,734.48 plus court costs of $168.28 to be paid on or before November 15th, 2023. However, there is a specific payment plan. So Ms. Caldwell shall pay $1,200 on or before November 17th. Defendant shall also pay $1,200 on or before December 1st. And then finally, the remaining balance plus December rent and fees to be paid on or before December 15th, 2023. I have explained Ms. Caldwell's rights under MCR 4.201J, and she did give me consent to sign on her behalf.
And ma'am, does the $4,734.48 include the December rent?
It does not.
Okay. Ms. Caldwell, were you able to hear the attorney's recitation of the settlement agreement in this case?
Yes, Your Honor.
And ma'am, you understand that if the court enters that consent judgment, you won't have a hearing in this matter?
Correct.
And you wish to agree to pay that $4,734.48 plus $168.28 in court costs with payments of $1,200 on November 17th, $1,200 on December 1st, and the balance of that $4,900 plus the December rent by December 15th, 2023.
Yes, Your Honor.
And because you appear on Zoom, there's not a signed consent. You've authorized the plaintiff's attorney to sign your name to the consent judgment.
That is correct, Your Honor.
And you understand that because you're not represented by an attorney, the judgment will not be final and enforceable for 3 days.
Correct, Your Honor.
Do you have any questions at all, Ms. Caldwell?
No, Your Honor. I feel like this is give me the amount of time that I need to correct this issue that I've got.
Thank you. Then, ma'am, what the court will do is await receipt of the consent judgment that has the terms that have just been placed on the record. Ms. Caldwell, do you need financial assistance with paying this past due rent?
I don't think I'm eligible, unfortunately, due to my income, but I went 4 months with only 70% of my income. So I don't know if I am eligible for it at this point.
There is Wayne Metro in the building right next door to the court. They're in the old courthouse. If you want to reach out to them and see if you're eligible, at least be screened for eligibility. If that might be of assistance to you, that's outside and in addition to the consent judgment that you just reached.
Okay, so that's called Wayne Metro, you said?
Yes, ma'am.
Do you have a phone number by chance for there?
I don't think, hold on one second. I don't know that I have it here. It should have been included in your mailing of the summons and complaint in this case. I'm looking right now, but their information is readily available online. If you want to Google Wayne Metro, their office is right here on Wayne Road, right in the building behind the courthouse, right behind the library, if you're familiar with the area.
Okay, awesome. I will go ahead and see what they can help me with because maybe they can help in this matter. I thought I was kind of ineligible, so I didn't even think of to even reach out to anybody.
I'm just saying it's worth the ask. There's nothing to be lost by at least reaching out to them. Okay.
And
Your Honor.
If there's nothing else.
Is there
Sorry.
stipulations different than like
Ms. Caldwell?
Yeah.
There's an attorney on right now from Legal Services, I think, who's trying to intervene and not intervene, but maybe provide some information.
Yes, George of Lakeshore Legal Aid, not appearing in this matter, but Ms. Caldwell, I do have a number for Wayne Metro if you'd like it.
Oh, okay, awesome. Let me get that.
Thank
Hold
you,
on.
Mr. George.
Certainly. Let me know when you're ready.
I'm ready.
734.
Yep.
284.
284.
6999.
So is there like stipulations, is it different than like CERTA or whatever it's called? I'm sorry, the government help place?
It depends on what you're applying for at Wayne Metro.
Okay.
But it's worth getting in touch with them and seeing if you qualify.
Absolutely. I appreciate you guys giving me that information because I'm going to get in contact with them ASAP and figure out what they could help me with.
Yeah, you may want to ask them about the HPP program. That's Hotel Papa Papa.
Okay, cool. The HPP you said?
Correct.
Okay, thank you so much, sir.
You're welcome.
Thank you, Mr. George. Ms. Caldwell, other than that, you're free to go, ma'am. You have a wonderful day. Good luck to you.
I appreciate it, and thank you so much for your help with this matter.
Did you have anything else with us this morning?
Your Honor, I have a bunch, but they start at 11, I believe.
Not with, no,
Not with you?
not with me.
Okay.
My last case is at 11. It's with Mr. George.
Thank you so much.
Have a good day.
You too. Bye-bye.
Mr. George, I'm stepping off, but I'm not going far. If Mr. Cox appears, Marianne will let me know and I'll come right back out.
Okay, thank you.
Thank you.
Mr. George?
Yes.
Hi, do you need a breakout room with Miss Allison?
Yes, please.
Okay, thank you.
Hello again, Marianne. Hi, Ms. Gambles. Sit tight for just a minute. We're going to have the court put you and me in a separate breakout room to talk things over in just a minute, okay? I can't hear you, Ms. Gambles. Could you say something to see if your microphone is working?
It was down low. Is that better?
There we go. Yes, I've got you now. Your Honor, if I could briefly step into a breakout room with Ms. Gambles, please. I think we have a resolution. I just need to talk it over with her.
Absolutely.
Thank you.
This is 2301276 LT Home Partners versus Gambles. May I have your appearances, please?
Attorney Elizabeth Ellison, P82098 for the plaintiff, Your Honor.
Good morning again, George of Lakeshore Legal Aid, P76776, on behalf of Kay Gambles, who is also present in the Zoom courtroom.
All right, Kiki with
Thank
Gamble.
you. Thank you, Ms. Gamble. Today is the day and time set for the adjourned hearing. Mr. George, how are we proceeding this morning?
Your Honor, we have the terms of a consent judgment to put on the record. The rent to retain possession is $46,405.17. Costs of $172.66 for a total rent to retain of $46,577.83. We have agreed that Ms. Gamble shall have until December 16th, 30 days, to pay that amount. She is working with several organizations to get assistance, and we're hoping that that comes through in the meantime. This is a possession-only consent judgment, and there is an agreement that if it is paid, Home Partners agrees to set this aside.
All that is correct, Your Honor.
Thank you. And who's preparing this document?
Ms. Ellison has already prepared it and sent a copy over to me. Ms. Ellison, I can either sign that and return it to you, or if it's easier, I will give you my permission to sign on the record.
Okay, I will. Yes, I can sign and submit it. Not a problem.
Thank you.
Thank you, Ms. Ellison and Mr. George. I will note that those are the terms of your agreement, and I will await receipt of the consent judgment. Anything else, Ms. Ellison?
Not from plaintiff, Your Honor.
Anything else, Mr. George?
Not at this time, Your Honor.
Thank you. Ms. Gambles, good luck to you. Ma'am, you have a wonderful afternoon.
Thank you. You too. Thank you, guys.
Thank you.
Thank you, everyone. Have a good day.
You too.
And that concludes our docket for the day. We stand adjourned.